So I don't know if you've heard of Hermes, which is kind of one of the highest, kind of top tier fashion brands out of Paris. They're famous for their Birkin bags, all sorts of like leather goods, whatever. So there is an artist, an NFT maker, however you want to call him. His name is Mason Rothschild, and he produced 100 MetaBirkins, which is NFTs that kind of riff on the Birkin bag. Well, Hermes wasn't so happy about that and sued Rothschild for these MetaBirkins, saying that it was an infringement of IP. Well, they won, but Rothschild is not kind of like taking this lying down. He's appealing, saying that, hey, if Andy Warhol can make Campbell soup cans and everybody calls that art, why can't I make these NFTs of Birkin bags? And what's the difference here?
I get the point. I think I understand that completely, right? And because that classic like Marilyn Monroe like and it's just variations of Marilyn Monroe. So I understand what he's saying. But this is such a rip of the Birkin. It is like, and I do understand the argument too that it's brand dilution, right? Like I think this is the Lantham Act case where, like, you create you flood the market with this like MetaBirkin, like these, and you're like, oh, maybe it values the brand. Where you're like, oh, like I've got thousands of these MetaBirkins eventually, right? I have no clue what the long-term goal is. And now all of a sudden it cheapens the brand where you're like, oh, well, I've got these digital Birkins. Like, I don't care about the real thing, right? Granted, I think the market is shifting. I don't know if it's actually shifting in favor of NFTs, so maybe that's not entirely accurate. But I at least understand the legal rationale here. But again...
Or at the very least, if I make Birkin bags in reality, and in IRL Birkin bags, and you're going to make them online, and you're going to get money from that... that's money that I should
literally
be
profiting from my IP. Yeah,
100%. Yeah.
What if Hermes wanted to make MetaBirkins?
Right.
It's their Birkin. It's their IP.
Exactly.
Yeah.
Now, Vogue Business.
I'm gonna make MetaBirkins.
I'll join you. So Vogue Business has said that the center of this case is something called the Rogers test. Now, in the late 1980s, Ginger Rogers, who was a major Hollywood actress of her era, sued an Italian filmmaker for basically stealing her name in a movie that he made called Rogers Astaire. So something called the Rogers test has appeared, and that's kind of like how a lot of trademark cases are now decided, is if does it pass the Rogers test or not. The Rogers test saying that if trademark has no relevancy to an artistic work, or if it's like blatantly misleading, then it that's the muster of the Rogers test. So this is something that, the jurors in this case said this does not pass the Rogers test. And yeah.
It'll be interesting. And I think you're going to, I tend to agree. Like, and I fully expected if it went the other way, or depending how the appellate process proceeds, you could have like someone making the Meta Nike, the Meta whatever, and just ripping these iconic brands and these iconic, things. Like it could be the Meta Jordans. And that's ridiculous. You're complete. I understand the argument there, and I think it makes complete sense to me on the Hermes side. I want to clarify something because I think my brain is scrambled. I think I said Latham, like the law firm, for the act. If you're listening to this and you're an IP attorney, I am sorry. I did not. That is not the correct pronunciation of that act. It's Lanham Act or whatever. I know I'm gonna get roasted on Twitter for that. I hope you enjoyed this episode. If you did, like and subscribe wherever you get your podcasts. Check us out also on LinkedIn and Twitter to keep up to speed with what we're doing. Catch you on the next one.